very immense happy to see your Lordship in the second lecture to our association. Your Lordship earlier also rendered a speech here on criminal law. It was overwhelming response from our advocates and other our friends. Now I request our orientation committee chairperson Dr. ALAGUMANI sir to welcome us.
MBHAA orientation committee நடத்தும் இந்த பயிற்சிக்கு வந்திருக்கும் வழக்கறிஞர்கள் அனைவரையும் வரவேற்கிறோம். மற்றும் இந்த பயிற்சிக்கு முழுமுதற் காரணமாக இருக்கும் எங்கள் சங்கத்தின் தலைவர் திரு பி. ஆண்டிராஜ் அவர்கள், செயலாளர் திரு அன்பரசு அவர்கள் மற்றும் ஆஃபீஸ் பேரர்ஸ் அனைவரையும் வரவேற்றுக் கொள்கிறோம். நமது நீதியரசர் அவர்கள் கடந்த 14/12/2022 பீனல் கோட் ஓவர்வியூ என்ற ஃபர்ஸ்ட் பார்ட் பயிற்சியை நமக்கு வழங்கினார்கள். அது நமது வழக்கறிஞர் இடையே ஒரு பெரிய வரவேற்பை பெற்றது. நமது வழக்கறிஞர் நண்பர்கள் தொடர்ந்து நமது தலைவர் செயலாளரிடம் நீதியரசரை மறுபடியும் அதை போன்ற ஒரு பயிற்சிக்கு அழைக்குமாறு அன்பு கட்டளையை தொடர்ந்து விடுத்தனர். அந்த கட்டளையை நீதியரசரிடம் சமர்ப்பித்தவுடன் உடனடியாக ஏற்றுக்கொண்டு நம்முடைய வருவதற்கு இசைந்தார். அவருக்கு எங்களது சங்கத்தின் சார்பாக நன்றியினை தெரிவித்துக் கொண்டு நீதியரசரை அன்புடன் வரவேற்கிறோம். நீதியரசர் அவர்கள் கடந்த 1969ஆம் ஆண்டு பிறந்தார். மாண்புமிகு மூத்த வழக்கறிஞர் திரு எஸ். சுந்தர் அவர்களுக்கும் திருமதி அம்மா சுப்பு லக்ஷ்மி அவர்களுக்கும் மகனாக பிறந்து சென்னை சட்டக்கல்லூரியிலே சட்டம் பயின்று சட்டத்துறையில் வித்தகர்களாக பிறந்த மாமேதை திரு என் என நம்மால் அன்புடன் அழைக்கப்படும் திரு என் நடராஜன் மூத்த வழக்கறிஞர்களிடமும் முன்னாள் மாநில அட்வொகேட் ஜெனரல் திரு ஹபீபுல்லா பாஷா சார் அவர்களிடமும் இந்நாள் அட்வொகேட் ஜெனரல் திரு சண்முகம் சுந்தரம் சார் அவர்களிடமும் இணைந்து பணியாற்றிய பெருமையுடையவர். அது மட்டுமல்லாமல் கடந்த சட்ட சஞ்சிகைகளில் லா ஜேர்னலில் நமது நீதியரசர் வழக்கறிஞராக இருந்த பொழுதும் 2012 ஜூன் மாதம் நீதியரசராக திகழ்ந்த பின்னரும் தொடர்ந்து அவரது தீர்ப்புகள் மாண்பு நீதியரசரின் தீர்ப்புகள் தொடர்ந்து வெளியாகிறது. தற்பொழுது லா வீக்லி, MLJ கிரிமினல், தமிழ்நாடு லா ரிப்போர்ட்டர் போன்ற அனைத்து சஞ்சிகைகளிலும் நீதியரசரின் தீர்ப்புகள் தொடர்ந்து வெளியாகிறது. மார்ச் ஆஃப் லாவிலே நமது மாண்புமிகு சென்னை உயர்நீதிமன்றத்தின் மாண்புமிகு நீதியரசரின் தீர்ப்புகள் தொடர்ந்து முத்திரை பதித்து வெளிவந்து இந்திய நீதித்துறைக்கு ஒரு வழிகாட்டியாக திகழ்ந்து கொண்டிருக்கிறது. அத்தகைய நீதியரசர் நமது ஓரியன்டேஷன் புரோகிராமில் கலந்து கொண்டு நம்மிடையே பீனல் லா ஓவர்வியூ பார்ட் 2 என்ற தலைப்பிலே உரையாற்ற வந்ததற்கு சங்க உறுப்பினர்கள் உங்கள் அனைவரும் சார்பாகவும் நன்றியை தெரிவித்துக் கொண்டு விடைபெறுகிறேன். நன்றி, வணக்கம்.
Now I request our President Mr. ANDIRAJ sir to honor our chief guest, Hon'ble Justice Sunder Mohan ji. Your Lordship, when you are swearing ceremony, Your Lordship mentioned that your father wanted you to become this honorable court judge. Lordship, it happened fortunately, because every day we listen, especially when your Lordship come to 482 portfolio, we see all your caliber and the academic and the spark knowledge, everything Lord. And most precisely, your Lordship, the MBHAA, now I request you to deliver the speech on criminal law and overview, Lordship.
Thank you, President and office bearers of the association. Now, the last occasion when we spoke about penal code, your President requested me to talk on culpable homicide and murder. So we will concentrate on these two offences, which are the main offence, if I may say so, in the penal code. This is ultimately only death sentence can be awarded to murder. Now we saw what are the mental states that are found in mens rea, broadly called as mens rea. What are the mental states we found in the last occasion when we met? We discussed about that. The mental states are, can anybody recollect? Knowledge, very good. Well, then preparation is the stage of the crime. Mental states, mens rea is the first stage. What are the mental states that are found in the penal code? One is intention, knowledge. Second, these are primarily found for all body offences. There is one more mental state, reasons to believe, that you will find in voluntarily, definition voluntarily in section 39. Now all these three mental states will be found in one offence. Usually it is only either intention or knowledge. All these three mental states will be found in one offence. Can anybody guess which is the offence? Try. Just make a guess. Grievous act la rendu dhaan. Body offence la intention, knowledge. Section 499. If you have penal code, please check section 499. You will find, I will read it for you, or give you can give it to one of them to read it. Penal code 499 padinga. First we will have to understand the mental states to understand culpable homicide and murder. That's why I want that to be very clear in your mind. Somebody read 499.
Whoever by words either spoken or intended to be read or by sign or by visible representations makes or publishes any imputation concerning any person intending to harm,
intention varda, intending to harm, intention, then or knowing, knowledge. This is second mental state, knowledge,
or having
reasons to believe. So these three mental states are found in only in this provision. In the entire penal code, you will find that three mental states are found in this provision. Alright, what is the difference in the three mental states? Now we have to understand this to understand culpable homicide and murder. What is the difference between these three mental states? Now reasons to believe is defined in section 39 is voluntarily. Reasons to believe is defined in section 26. Alright. Reasons to believe the lowest degree of mental state. Adukku higher state is knowledge, slightly higher state is intention. Right? Now I gave you an example last time. Supposing I am just recollecting what we discussed last time. Supposing a person comes to your house at 12 o'clock in the night with some jewels and says that you take it for half the price. He has not told you that it is stolen goods. It appears that he has stolen. So you have reasons to believe. That is not direct knowledge, but you have reasons to believe that it is stolen. So this is one type of mental states. So you can infer reasons to believe. That is one type of mental state. Knowledge is what you have, what you know. That is tested by average man's knowledge. Ellaroda knowledge, it will not be the same. So law prescribes a rule that the average man's knowledge is to be taken. What is average man's knowledge? If you strike a person with a weapon, it will cause hurt to him. He will die. That is an average person's knowledge. That is why we have certain exceptions, like insane person's act is not an offense. You have insanity as a difference in. So average person's knowledge in knowledge always is tested in terms of average person's knowledge. Okay. What is then intention? Intention is you have the knowledge and you have the desire to do it. The next stage, that is the highest form of mental state, highest degree of mental state, which is culpable. So first reasons to believe, they ignore pannunga. For the time being, ignore the mental state of reasons to believe. You have knowledge and intention. So knowledge is, you don't have the desire to do it, but you know that this will be the desired result. I'll make myself really clear. Supposing ஒரு கார் எடுத்து we go to a crowded place, நல்ல நேராக கொண்டு போய் மோதுறோம் in a crowded place. We know, or the person who drives knows, that the desired result will be either one or two people dying. Yeah, that is knowledge. But he may not have the desire to kill that A or B who is standing. Desire irukad, but he has only the knowledge. Now, in the example, now let us take it. Now, he wanted to kill A or B nu vechukanga. அப்போ வந்து இந்த கார் எடுத்து போய் கொண்டு போய் மோதுறாரு. A and B are there. He knows that A and B are standing, therefore I am going to do it. So he has both knowledge that this by this act he is going to kill that person, and he has the desire to do it. Okay. Now knowledge ku vandu intention ku, therefore two ingredients are there. Intention, the mental state of intention ku rendu ingredient irukku. Knowledge um venum, then the desire to do it. Now this fine distinction you must understand. In criminal law, in the mens rea la இவ்வளோ distinction இருக்குன்றதை we first get must understand that. All right. Now இப்போ intention and knowledge only is discussed in culpable homicide and murder. Now the difference between culpable homicide and murder, as the courts themselves feel, is a vexed question. Vexed question is, this question crops up often. What is the difference? Now, over a period of time, they have simplified this difference very well. Difference between culpable homicide and murder. So, what is culpable homicide? Forget what is defined in penal code. Culpable homicide na inna? Punishment? அப்படின்னா என்ன? பனிஷ்மெண்ட் கம்மி. எவ்வளோ பனிஷ்மெண்ட்டுன்னு கேட்கல. வாட் இஸ் கல்பபிள் ஹோமிசைட்? புரியல. திடீர் ஆத்திரம் விட்டுனால பண்ணுறது. இன்டென்ஷனும் இருக்காதுல. கரெக்ட். ஹோமிசைட்னா முதல்ல என்னன்னு தெரிஞ்சுக்கணும். ஒருத்தர் வந்து if he kills another person, it is homicide. If a person causes the death of another person, it is homicide. Man killing another man is homicide. சரிங்களா? சூசைட்னா தன்னைத்தானே கொல்றது, சூசைட். ஹோமிசைட்னா a man, one person killing another person, taking away, causing the death of another person, that is homicide. First understand பண்ணி. Then culpable na punishable. All homicides are not punishable. Culpable homicide, that is punishable homicide, that is culpable homicide. The definition காக சொல்கிறேன், அதுக்குள்ளே இருக்கிறதெல்லாம் அப்புறம் படிப்போம். Now this is culpable homicide. நான் என்னென்னு புரிஞ்சுக்கிட்டீங்களா? plain English language. Culpable is punishable. Homicide is causing the death of one person, causing the death of another person. Now இதுக்கு next stage is called murder. Now culpable homicide க்கு punishment is lesser. Culpable homicide not amounting to murder is lesser. All culpable homicides are murder. அதாவது culpable homicide ஒரு பெரிய சர்க்கிளாக இமேஜின் பண்ணிக்கங்க. அதுக்குள்ளே இருக்க சின்ன வட்டம் murder. ஸோ எல்லா culpable homicideம் is not murder. The culpable homicide is all murders are culpable homicides, but all culpable homicides are not murders. So the larger circle is culpable homicide. அதுக்குள்ள ஒரு சின்ன வட்டம் murder. இதையும் நம்ம புரிஞ்சுக்கணும். Now imagine this as a larger circle. Kalpa homicide is a larger circle and a smaller circle inside is murder. So இப்போ இந்த now imagine this two circles, என்னென்ன acts எல்லாம் will fall within culpable homicide and what are the other acts will fall within the smaller circle of murder. இதுதான் நம்ம பார்க்க போகிறோம். நம்ம அந்த டிஸ்டிங்ஷன் நம்ம கிளியராக புரிஞ்சுக்கிட்டோம்னா it is easy to conduct any criminal case. Forget murder cases, you have to understand and that clarityயோட படிக்கணும். Now section 299 defines culpable homicide. அது எல்லாருக்கும் தெரியும் இல்லையா? Alright, one of you read 299.
Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with knowledge that he is likely by such act to cause death commit the offense of culpable homicide.
சரி, இதில் வந்து இன்டென்ஷன் ரெண்டு இடத்துல இருக்குது, நாலேஜ் ஒரு இடத்துல இருக்குது. மூணாக பிரிச்சுக்கோங்க. 299 split it to 3 classes, 3 parts. The first part deals with intention to cause death. Okay, what are the acts? Imagine panninga, what are the acts that can intention to cause death பண்ற act என்னன்னா? Gunshot, very good. அருவாள் எடுத்து கழுத்துல வெட்டுறது or any vital part. Okay, that is intention to cause death directly, you can infer. That is the first part. There is no difficulty in understanding that. If a person causes does an act with the intention to cause death, that is clearly culpable homicide. Correct? Now second part. Now the intention here is not to cause death. Nalla புரிஞ்சுக்கங்க. Second part படிக்கும்போது the intention is to cause only the bodily injury that is likely to cause death. Okay, now this is the second part. ரெண்டு intention இருக்கு. One is intention to cause death directly. There is no difficulty in understanding that. The second part deals with intention to cause bodily injury that is likely to cause death. Very good. All right. அது எந்த மாதிரி இன்ஜுரி சொல்லலாம்? ப்ராபபிளாக நடக்கலாம். டெத்து காலை வெட்டுறான்னு வச்சுக்கோங்க. சப்போஸிங் ஹி கட்ஸ் அ லிம், பிளட் சர்க்குலேஷனில் he might the probability of death is there. Probability of death is there. Oh, which is likely to cause death, but his intention is not to cause death. That is, you infer from the site of the injury. அதை வச்சு நம்ம இன்ஃபர் பண்ணலாம் இந்த whether it's the intention to cause death or intention to cause bodily injury that is likely to cause death. Supposing ஒருத்தர் கை வெட்டாருன்னு வச்சுங்க, after 10 days the man dies. He can be brought under the clause 2 of section 299, that he has intention to cause a bodily injury that has resulted in death, so it is likely to cause death, therefore it falls within 299 second part. Now first two parts clear? Alright. Now the third part deals with knowledge. Now here it is not the intention. He doesn't intend that act. Supposing ஒரு கேர்லெஸ்ஸாக ஒரு கருங்கல் எடுத்து ஒரு க்ரௌடட் பிளேஸ் மாடியில் இருக்காரு, கருங்கல் எடுத்து போடுறார். There he has knowledge that is likely to cause death. So sometimes it may fall on the vacant place also, but sometimes it may fall on a person. Suppose he closes his eyes, இங்கே டெரஸ்லேருந்து யாருன்னே தெரியல, சும்மா ஒரு கல் எடுத்து போடுறாரு. You can infer knowledge. So நான் நாலேஜை பொறுத்த வரைக்கும் what did I say? It is average man's knowledge. அவரோட நாலேஜ் இவருக்கு இது தெரிஞ்சதுன்னு சொல்லணுன்ற அவசியம் இல்லை. So far as intention is concerned, it is that person's intention. இந்த டிஸ்டிங்ஷனும் நான் சொல்ல மறந்துட்டேன். Please remember that when you are talking about intention, it is that person's intention. அது average man's intention எடுக்க முடியாது. ஏன்னா intention is specific to a person. Knowledge பொறுத்த வரைக்கும் it is average man's knowledge you have to take. So இது இந்த distinction now. இந்த knowledge நம்ம பார்த்துட்டோம் இல்லையா? knowledgeலையும் பார்த்தீங்கன்னா you will see knowing with the knowledge that is likely by such act to cause death. So இங்கே the two words used in the second part and third part of section 299 is likely to, like the word used is likely. These acts to become, இது வந்து clearly punishable. இந்த மூணு act பண்ணா it is culpable homicide. In order to bring this case within murder, what is the additional mental state or what additional ingredient that the prosecution has to prove? இதுதான் நம்ம பார்க்க போறோம். Now take 300 எடுத்துக்கோங்க. One of you read 300.
Except in the case herein after accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death or.
ஒரு நிமிஷம். இப்போ இந்த ஃபர்ஸ்ட் சென்டென்ஸ் நல்லா புரிஞ்சுக்கணும். திருப்பி ஒரு அடி படிங்க. Read it once and try to understand, then I will explain. நீங்களே ட்ரை பண்ணுங்க, then we will explain this, how this first sentence has to be, first part has to be understood.
Except in the cases herein after accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death or.
Culpable homicide la first part enna paathom? If the intention is to cause death, it is culpable homicide. Okay, here also we find that if the intention is to cause death, it is murder. Correct? Okay, now in the first part la, if the intention is to cause death, culpable homicide சொல்றாங்க, murderum அதே definition தான். But if it falls within any of the exceptions, it becomes culpable homicide. You have the intention to cause death. If a person has the intention to cause death, vechukanga, it is clear case of murder. But if it falls within any of the exceptions, and the exceptions 1 to 5 irukku parunga in section 300, 5 exceptions irukum. If it falls within any of the exceptions, then it becomes culpable homicide. It is not murder. So except in cases hereinafter accepted, culpable homicide is murder if it's done with the intention to cause death. Varudha? So in the exceptions la varavillai என்றால், then any person who does an act with the intention to cause death, it automatically becomes murder. Understood? But அது culpable homicide இருக்கு அந்த definition. ஏன் இருக்கு அப்படின்னா, if it falls within the exceptions, it goes to culpable homicide. So இங்கே வந்து பார்த்தீங்கன்னா the act is the same, intention to cause death is the same, but provided it comes within any of the exceptions, it becomes a culpable homicide. It is not murder. In the exceptions la varlana vanduchina, it is becomes a culpable homicide not amounting to murder. You understood? So intention to cause death is clearly murder, but if it falls within any of the exceptions, it is culpable homicide not amounting to murder. In the first part. Now idor nikila. Now here inimel da complicated questions will come now. I'm trying to simplify it as much as possible. All right, நம்ம இப்போ second part பார்த்தோம் இல்லையா? நம்ம first part of 299 deals with intention to cause death. That we have now clearly understood. Intention to cause death, that becomes murder automatically, but if it comes within any of the exceptions, it becomes culpable homicide. Now that is clear? Correct. Now the second part, இங்கே தான் slight complications will arise. ஒன்றும் இல்லை, சிம்பிளாக புரிஞ்சிக்கலாம். Now second part deals with, of 299 deals with intention to cause injury that is likely to cause death. சரிங்களா? அது வந்து clearly culpable homicide. Okay. Now the second part of 299 is split into two parts in 300. That is, clause secondly and clause thirdly will correspond to the second part of section 299. இப்படி வச்சுக்கோங்க. First remember this. Clause secondly and clause thirdly of 300 will correspond with the second part of 299, that is where the intention is to cause only the bodily injury. Okay. In murder also, if there is an intention to cause bodily injury, then it can become murder in certain circumstances. அது என்னென்ன circumstances அப்படின்றத பார்ப்போம். Now read secondly.
Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused.
Now இதுக்கும் அந்த second part of 299க்கும் what is the difference? Now you tell us. One of you see the difference. இதுக்கும் second part of 299க்கும் என்ன difference? The offender knows it is likely to the death of, அதாவது இங்க intention is to cause bodily injury. இந்த அஃபண்டருக்கு மட்டும் தெரியுது, இதில் வந்து காமன் மேன் அஃபண்டர் நாலேஜ் கிடையாது. அஃபண்டருக்கு தெரியுது தட் இந்த இடத்துல இவர் அடித்தா இவர் இறக்கக்கூடும், தட் இட் வில் காஸ் டெத் டு ஹிம். அதாவது சாதாரணமாக ஒருத்தரை வந்து நீங்கள் ஒரு ஃபிஸ்ட் பண்ணிங்கன்னா சாக மாட்டார். he will not ordinarily die because of physics. Supposing he has a pacemaker, that offender knows this guy as this person as a pacemaker. Then if he fists him on that particular place, it may cause death to him. This exclusive knowledge of the appellant or the accused is using it. So that is shows his aggravated or the higher degree of mental state. That is higher degree of mental state. அதாவது சாதாரணமாக he won't die by that act. Supposing ஒரு சர்ஜரி பண்ணியிருக்காருன்னு வச்சுக்கோங்க, ஸ்டமக்கில் ஒரு சர்ஜரி பண்ணியிருக்காரு. தி அஃபண்டர் நோஸ் இஸ் காட் அ சர்ஜரி, அதில் போய் குத்துறாரு. ஸோ இதில் வந்து என்னென்ன இன்க்ரீடியன்ஸ்? he must cause an injury. The offender must know that by causing that injury this person will die, is likely to cause the death of the person to whom the harm is caused. ஸோ இதில் அங்கே வெறும் likely to cause death தான் இருக்குது செகண்ட்லியில். இங்கே offender knows, though this is additional ingredient which is required to be established to prove murder. புரிஞ்சுங்களா? இது வந்து far and few between. You don't have to worry about this. இது வந்து 1000 கேஸில் ஒரு கேஸ் வரும். அதாவது ஏன் வராதுன்னா, ஒரு பர்சனுக்கு டிசீஸ் இருக்கணும், அந்த டிசீஸ் பற்றி அக்யூஸ்டுக்கு தெரிஞ்சிருக்கணும், தெரிஞ்சு இவரை கொலை பண்ணணுன்ற வேறு இன்டென்ஷன் ஒரு மோட்டிவ் இருக்கணும். இது மூணும் சேர்றது வெரி ரேர். ஸோ இந்த செகண்ட் பார்ட் வந்து வெரி ரேர்லி யூ வில் ஃபைண்ட் கேசஸ் ஆஃப் திஸ் நேச்சர், வெரி ரேர்லி. அது ஃபேமிலி மெம்பர்ஸ், ரிலேட்டிவ்ஸ், க்ளோஸ் ஃப்ரெண்ட்ஸ்குள்ளே வரலாம். பட் இன் மை ஓன் எக்ஸ்பீரியன்ஸ் I have very rarely seen such a case which will fall under clause secondly of 300. So now you have understood secondly, but adukku நம்ம skip பண்ண முடியாது. We will have to understand what secondly is. Now thirdly is something that we must really understand. Now this is in the thirdly ku second part of 299 ku na lot of discussion, the case laws you will invariably get. Now read thirdly slowly. Now next time what I will do is I will prepare a PowerPoint and we will screen the difference. Now one of you can see the difference also here in one of in cases la you can paathu kuda neenga you can pass it on. Now please read clause thirdly.
If it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death.
So இங்கே வந்து என்னென்ன ப்ரூவ் பண்ணோம்? இன்டென்ஷன் இஸ் டு ஒன்லி காஸ் பாட்லி இன்ஜுரி. பட் செகண்ட் பார்ட் ஆஃப் 299க்கும் இங்கேயும் என்ன வித்தியாசம்? அங்கே லைக்லி டு காஸ் டெத், இங்கே வந்து sufficient in the ordinary course of nature to cause death. In the words difference there, can you see the difference? Sufficient in the ordinary course of nature cause death. This is that. All right. Now theory la we know one is likely to cause death, the another one is sufficient in the ordinary course of nature to cause death. Now in the difference we'll have to understand. So courts have held, what is this words likely, sufficient in the ordinary course of nature? How do you interpret this? Now the first earliest case is one Virsa Singh. Virsa Singh, make a note of it. It's the first case which discusses this entire issue on what is the difference between 299 second part and 300 third clause. Virsa Singh, 1958 Supreme Court, page 465. So in order to bring it within 300, Virsa Singh says 5 tests have to be fulfilled. First, it must establish prosecution to bring it within murder. If the intention is to cause only bodily injury, if the intention is to cause death, no problem, it's automatically murder unless it falls in the exceptions. First, it must establish quite objectively that a bodily injury is present. Or bodily injury first to prove on prosecution. Secondly, the nature of injury must be proved. What is the nature of injury? Two things. Either you will find in the post-mortem doctor's report. Bodily injury and the nature of injury. Cut injury, where is it present? Then 3. It must be proved that the accused had the intention to inflict that particular injury. What happens in many cases, in some cases the accused had taken the defense, நான் கையை தான் மிரட்டுறதுக்காக கையை தான் வெட்ட போனேன், அவர் மறைச்சி அவர் குறுக்க தேர்ட் பர்சன் கேமன் தடுக்க வந்தார், அவர் தலையில் பட்டுச்சு, மை இன்டென்ஷன் வாஸ் நாட் டு இன்ஃப்ளிக்ட் தட் பர்டிகுலர் இன்ஜுரி. அதையும் that is also one of the differences taken by accused in certain cases. So third, prosecution has to establish that the accused intended to inflict that injury. மூணு ஆச்சுங்களா? ஃபர்ஸ்ட் டெஸ்ட் வந்து இன்ஜுரி இருக்குன்னு சொல்லணும், then it must be proved that nature of injury. Third is the intention of the accused to inflict that injury. Fourth, must prove that. Then fourthly, it must be proved that the injury is sufficient to cause death in the ordinary course of nature. So idu vandu it is a purely medical opinion, that is the injury caused panna it is sufficient in the ordinary course of nature to cause. This is a medical so very often the accused might say, no, I did not intend to cause death, I intended to cause only this bodily injury. So other vandu they are now by the act says you can't take the defense if the injury by itself is sufficient in the ordinary course of nature to cause death, then it will come under clause 3 of section 300, therefore it will become murder. So Virsa Singh says, therefore in that 4 test irunduchina, then offense of murder is established, even though his intention was not to cause death, his intention is to cause only injury. Alright, now this is so far as intention to cause injury, second and third இப்படி பிரிக்கிறாங்க. Now இதே இன்னொரு ஜட்ஜ்மெண்ட்டில் என்ன சொல்கிறாங்க, டிகிரி ஆஃப் ப்ராபபிலிட்டி, அதாவது லைக்லி டு காஸ் டெத்ன்ற வார்த்தை வந்து இட் இஸ் இன் த ரெல்ம் ஆஃப் probable. That death is probable. Likely to cause death, death is probable. In the clause 3 of section 300, death is most probable. Degree of probability is higher. It is most probable. அதாவது இந்த மாதிரி இன்ஜுரி இருந்துச்சுன்னா it is most probable, but to bring it under 299 it is just probable. In fact, 2 days ago we have rendered one judgment in the division bench distinguishing between these two as most probable and probable. Probably it will be published a little later. The most probable and probable distinction panni, we have found one case where he can be guilty of only culpable homicide. The nature of the case was that கம்பியை வச்சு அப்பாவை தலையில் அடிக்கிறான், கீழே கிடக்கிற கம்பி வச்சு தலையில் அடி. ஸோ father dies 4-5 days later, but the intention was to cause bodily injury, which is likely to cause death because it is caused death. But his intention was, it is not sufficient in the ordinary course of nature. மற்றவங்கன்னா பொழைச்சிருப்பாங்க. He was an old man, 62 years, 4 days treatment was there. Therefore, we found that it was not a most probable result of this act. That is his act of beating with a iron small rod. So, idu oru pakkam irukattum. Now this is so far as clause 2 and 3 equivalent to clause 2 of 299 in the difference name. Now therefore, to bring it within murder of clause 2 and clause 2 of 299, to bring it with the murder, it has to either fit in secondly or thirdly of 300. Now fourth clause circle, that is of murder, it is has to be compared with third part of 299. So angiyum vaarthinga parunga, likely to cause death, knowledge that it is likely to cause death in 299. In 300 pathina, if the person committing the act knows that it is so imminently dangerous that it in all probability cause death or such bodily as is likely to cause, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Now see the difference in language. One வந்து likely to cause death, one he knows that in all probability it will cause death or such bodily injury that is likely to cause death. Now in the example of taking the car and ramming into a crowded person, he knows that in all probability it cause death. ஒரு கல்லத்தை அடிக்கிறாரு, as a small stone, a death is caused, it is likely to cause death, but in all probability it may not cause death. So அது வந்து you can bring it under culpable homicide not amounting to murder, and this is a in all probability. So is the degree of probability of death. This is an objective test, has to be seen and has to be seen in on a particular facts and circumstances of a case. ஒரு கேஸில் we can say it is only probable, his act is only probable or likely to cause death. In other cases we can always say, in certain other cases it may be that he is so imminently dangerous that in all probability it is likely to cause death. That is knowledge. Knowledge பொறுத்த வரைக்கும், where the desire to kill is not there. அது நல்ல ஞாபகம் வச்சுக்கோங்க. Intention and knowledge difference is, he knows that in the result will follow, but he does not have the desire to do it. அந்த ஆளை வந்து நம்ம கொலை பண்ணணுமோ அது இல்லை. In one case, what கோவத்தில் he says, he just throws the kerosene on the lady and then lights the matchstick. The court found that it will fall under clause 4 of 300. Though he had no intention, threaten பண்ணுறதுக்காக பண்ணுறான், he had knowledge that it is a very dangerous act, that it is so imminently dangerous that in all probability it causes death. Therefore it will fall within clause 4th of section 300, and he was convicted for murder. So without any excuse for incurring the risk of causing death அப்படின்னா அதையும் third another clause, without any one more exception கொடுக்குறாங்க. எக்ஸப்ஷனுக்குள்ள ஒரு எக்ஸப்ஷன், without incurring without any excuse for incurring the risk of causing death or such bodily injury. இது ஒரு பியூட்டிஃபுல் கேஸ்னா, அது a person, a lady, runs, unable to bear the torture of her husband, runs with her 2-year-old child. Her husband chases her. She jumps into the well. She jumps into the well. Now, her act is, she knows, Gudicha, Tanu Savala, the Kolandi Sav. Knowledge irka? Kolandi Kollanonu intention illa. Nalla punjikanga. Intention is not to kill. Now, inge da distinction between knowledge and intention varum. She knows that by that act, it may cause the death of the child. So that knowledge is there. She knows that it's so imminently dangerous. It's dangerous that in all probability it will cause the death of the child. She escapes, the child dies. She was prosecuted for murder. The court found, no, you can't prosecute her for murder. It at best only be a culpable homicide. It is not knowledge, it's no imminently dangerous. She had an excuse for incurring that risk. What is the excuse? Somebody was chasing her. Her husband was chasing her. She had an excuse. Similarly, this excuse for incurring risk can be used for where extreme poverty, you see that ladies usually consume poison and give it to the children also. As luck would have it, the lady would survive that poison intake. The children, some of them would have died. Then she would be charged for murder. So, adula kuda extreme poverty, they say that incurring risk can, without any incurring the risk, can be brought under. So, this was originally in our High Court, we had this called the Nallathangal syndrome. Ultimately, Supreme Court then said that cannot be accepted. But in my view, this can be brought under this excuse of incurring the risk of causing death. So, adiliyum or exception in fourthly also. So, the language employed in 299 is likely to cause death, which is probable. Death is probable. Here, most probable. Nichayamaga nadakakudum. Anga probable na, it can be either way, this way or that way. Inga most probable. Alright. What are the exceptions? Number 5 exceptions padichom. What are the exceptions? First is grave and okay. What is grave and what is sudden? This provocation must be grave. ரொம்ப சீரியஸாக இருக்கணும். And it must be sudden also. Grave and sudden. ஏதாவது ஒன்று இல்லைனா கூட it will not fall within. Okay. What is grave? It must be very serious. It must have the intention to provoke you. அதான் grave. அது உடனேவும் நடக்கணும். அதாவது அந்த ஸ்பாட்டில் நடக்கணும். ஒரு 10 நாள் கழித்து யோசித்து வந்து பண்ணால் அது grave இல்லை, அது மோட்டிவ். அது சடன் கிடையாது, மோட்டிவ். ஸோ in order to describe what is grave, அதையும் நிறைய டிஸ்கஷன்ஸ் இருக்குது. அதுக்கு the lead case is none of these case. கேள்விப்பட்டீங்களா? அதில் what is grave and sudden has been discussed beautifully. அதில் ஒரு இன்ட்ரெஸ்டிங் factor they consider is in order to consider whether it is grave or not, the previous conduct of the person also has been taken into consideration. அதாவது அந்த இன்சிடென்ட் மட்டும் இல்லை, இதுக்கு முன்னாடி நடந்த இன்சிடென்ட்டும் will determine whether that particular provocation is grave. அதுக்கு ஒரு எக்ஸாம்பிள். A man is a கூலி ஒர்க்கர். அவன் போய் whole day he works. He comes back home. He sees his wife with another man. இவனுக்கு பசியில் என்ன பண்ணுறான், அது கோவத்தில் என்ன பண்ணுறான், சாப்பிடாமையும் வீட்டுக்கு போயிடும், வேற எங்கேயோ போய் படுத்து தூங்கிறான். He is not angry, he is angry but he doesn't cause any harm. இது ஏதோ my wife has done this, therefore we'll go. Next day morning he returns home. He sees that wife and paramour having breakfast together someplace. Now, minus the previous day's incident, two persons eating breakfast together, can it offer provocation? By itself. Court said, you have to take into consideration the previous night's incident and what was there in his mind. He says, coupled with the previous night incidents, this incident is bound to cause provocation because avan pasila poran night thunga vera engiyo poi padukran, morning he says, and the wife doesn't repent, she eats breakfast with the other person, so that causes provocation for him and he kills both of them. That they bring it within grave and sudden provocation. So the previous conduct also has to be taken into consideration to determine whether it is grave. So this was considered in none of these cases. They invariably grave and sudden provocation cases are all dealing with adultery cases. Now, Indian cases fulla pathina you only deal with adultery cases where this grave and protection or certain words. Even Nanavati case is a case of adultery, but ultimately the defense of grave and sudden protection was not accepted by the. So this is grave. Now Nanavati's case is a must read. You must read. I will give you the judgment, and then the probable and most probable has been discussed in Tangaya's case. In the notes I will give it. Tangaya's case 2005 9 SEC page 650. Anyway, I will share this notes with your present, you can add it. None of these cases reported in 1962 Supreme Court 605. After a Delhi High Court judgment, Justice Muralidharan had authored it, you will find reported in 2018 SEC Online Delhi 7260, where this grave and sudden provocation in and along has to be satisfied to bring it within grave and sudden provocation. Now the second part deals with private defense. Second exception. Exception 2 deals with where is exception 2? Culpable homicide is not murder if the offender in the exercise of good faith or the right of private defense of person or property exceeds the power given to him by law and causes the death of the person against whom he is exercising such right of defense without premeditation and without intention of doing more harm than is necessary for the purpose of such defense. So exceeding private defense. Private defense, where do you get private defense? 96 to 106 la, you have a right to defend your property and body, and it includes the other man's body also. Unnortharoda property and body neenga prevent பண்றதுக்கு you have a right to exercise private defense. அந்த எந்தெந்த கேஸ் எல்லாம் நீங்க வந்து you can cause the death இருக்கு, எந்தெந்த கேஸ்லாம் you can cause harm அப்படின்னு 96 to 106 ல rules இருக்கு. That rules you have to understand. But when you are exercising private defense, you don't calculate the rules 196 to 106 rule வச்சிட்டு மனசுல வச்சிட்டு you don't do the right of private defense. So அதுக்கு ஒரு exception கொடுக்கணும்ன்றதுக்காக where you exceed, where the court feels, where the jury feels that you have exceeded, then you don't bring it within murder, you bring it within culpable homicide. Now the beauty of bringing it with the culpable homicide, you will see there is no minimum sentence. 1 day sentence கொடுக்கலாம் culpable homicide. So exceeding, if you exercise private defense, it's no offense. If you exceed it, it becomes culpable homicide, but for which punishment can go up to less than, there's no minimum punishment for that. Such a wide discretion is given to the courts. That is the beauty of penal code, where such discretion is given to the court to, so or a slight deviation or slight excess of private defense in the court can even restrict it to 1 month imprisonment. That kind of, that is why you will find that there is no minimum sentence in culpable homicide. It extends to maximum punishment only is provided. So this is exception 2. Exception 3 is where public servant exceeds his right of authority. While arresting, public servant can cause the death of another person also. Supposing he overpowers certain powers, public servant, when arresting, section 46 if I remember right of CRPC. ஸோ அந்த பவர் எக்ஸீட் பண்ணால் public servant will also fall within this exception. It will also amount to culpable homicide and not murder. He has also got only certain powers to cause, but if he exceeds, then he is also guilty. His act also becomes culpable, but it's not murder because it falls within 3. Now fourth is if it's committed in a without premeditation, in a sudden fight. So இதுக்கும் exception 1க்கும் ஒரு difference இருக்கு. Exception 1 provocation is offered by one person. Here it is mutual. The fight it becomes mutual, both fight. So in and the condition is it must be mutual fight, then it must be sudden fight. Other plan பண்ணி போய் fight பண்றது, it will not come within the exception. So if you are able to show that it is a sudden fight, then you can bring in the exception. Then fifth exception is not murder when the person whose death is got being above the age suffers death or takes the risk of death with his own consent. What happens in sometimes both will enter into a suicide pact, husband and wife. ஒருத்தர் வந்து இறந்துருவார், ஒருத்தர் சர்வே பண்ணுவார். So there invariably they bring it within this clause. So that exception, there is an exception under private defense. The exceptions irukku, that is if he voluntarily takes a decision, then he will not be liable. But adayum exceed panni inda adla or thin line of difference irukku. Now for want of time I am going fast because we have already started late. All of you are very tired. So and the distinction of general exceptions ko irukra distinction exception 5 ko very thin line of difference that you will find the general exceptions la section 88, 87. You have to compare that with exception 5. I leave the notes with you. We'll do another session in a daytime on a holiday also we can do, so that we have more time. That will be better. So with this I'll stop for today. Thank you so much.
Request President to say about the Lordship and his lecture.
Section 299 300 இவ்வளோ சிம்பிளாக ஒரு எலிகெண்ட்டாக சொல்கிறது கஷ்டம். ஏன்னா ஐ கன்ஃபைன்ட் மை செல்ஃப் இன் கிரிமினல் சைல்ட் லாட் லைக் அவர் லார்ட்ஷிப். ஐ பிலாங்ஸ் டு NN ஆஃபீஸ், ஐ பிலாங்ஸ் டு NT வானமாலை ஆஃபீஸ். யூ டேக் விர்சா சிங் அண்ட் தங்கராஜ் கேஸ் அண்ட் நானாவதி. இது ஒரு எக்ஸலண்ட்டான ஒரு நீங்கள் ஃபாரின் லாஸ் கூட பாருங்கள். இட்ஸ் அ பியூட்டிஃபுல்லி என்கிராஃப்டட் ப்ரொவிஷன்னா 300 தான். இந்த ப்ரொவிஷன் உலகத்தில் எங்கேயுமே கிடையாது. இந்த மர்டருக்கு எக்ஸப்ஷன் கொடுத்தது நம்மளா தான். அது வந்து ரொம்ப அழகாக சொல்லியிருக்காங்க. இப்போ அவங்களே தெரியாமல் கன்ஃபர்ஸ் பண்ணிட்டாங்க லீவ் நாளில் வர்றேன்னு. கண்டிப்பாக நம்ம அதை யூஸ் பண்ணிப்போம். தேங்க்ஸ் டு ஒன்ஸ் மோர் அகேன் அவர் லார்ட்ஷிப். தேங்க்யூ
Lordship. Our nostalgia went to law college and rewind ourselves, and your Lordship put it very simplistic way with all the case laws, and we thank for your rigorous research on this Lordship. Now I request our orientation committee member Mr. A.P. Das to say vote of thanks.
மாபெரும் இந்த சிறப்பு நிகழ்ச்சிக்கு வருகை தந்து தலைமையேற்கும் நீதியரசர் அவர்களுக்கும், இந்த நிகழ்ச்சியை தொகுத்து வழங்கி வரும் மூத்த வழக்கறிஞர் ஆர் அழகுமணி சார் அவர்களுக்கும், ஆர் கருணாநிதி சார் அவர்களுக்கும் மற்றும் பெத்து ராஜேஷ் சார் அவர்களுக்கும், இந்நிகழ்ச்சியை ஏற்பாடு செய்து கொடுத்து நமது சங்கத்துக்கு ஆணிவேராய் இருந்து வரும் தலைவர் செயலாளர் அவர்களுக்கும், இந்த நிகழ்ச்சிக்கு வருகை தந்து அமைந்திருக்கக்கூடிய மூத்த மற்றும் இளம் வழக்கறிஞர் பெருமக்களுக்கும் மனமார்ந்த நன்றியினை தெரிவித்துக் கொள்கிறேன்.